5, 4, 3, 2.
Hello, Kako, and welcome to Kanaka Express. I'm Kali Guapak, your host for this evening, and again, we'd like to be able to thank you for allowing us into your home. We have a really good show tonight, and we're going to be talking about war crimes. And some of you may be hearing this term, especially in the last couple of weeks, and if you haven't heard it, we're going to be teaching you about it, and some of you are wondering, what? War crimes? Especially here in Hawaii. And this is why we're going to be talking about it, so that we can explain it, how it's being applied, and so forth. I'd like to welcome my guest, Dr. Ke'ano Sai, and again, this is a serious topic that we're going to be talking about. And don't turn your television station, because this is something that is coming up here in Hawaii, and you need to learn about this and why and how it's being applied. Dr. Sai, welcome to the Kanaka Express.
Hello.
I mean, it's not like you're new to the show, because everybody knows about you and the Kanaka Express and all of the different topics, and it's a really popular show on Olelo as well as Akapu, and hopefully one day on Leo. So we're going to be talking about war crimes. Let's take it from the beginning. How did war crimes come about?
Well, the term war crimes was actually not a topic or a word in of itself until 1919. Okay, prior to that, you had what was called the laws of war and the laws of occupation. Now, the laws of war and the laws of occupation were regulated by international law. In particular, for the United States, it was first administered through an internal code called the Lieber Code that regulated the U.S. military, in particular the Army. It regulated them in the occupation of foreign territory. Yeah, so one of the rules is that when you invade a country, you don't have the sovereignty of that country. You have what is called the temporary control of that sovereignty, which means you administer the laws of that country. You know, what you try to do is maintain civil order, but also mindful of they're still at war. So there are things that you can do, but there are things that you cannot do. Now, the Lieber Code was later replaced by the 1899 Hague Convention, which was a multilateral treaty signed between countries in the Netherlands, in a city called The Hague in 1899. In fact, it was Tsar Nicholas II that organized these countries to come together to regulate the laws of war. Okay? Later, that was later succeeded by the Hague Convention of 1907, which really just a reiteration, but refining certain points of the laws of war and occupation. Now, the idea of violating the laws of war was not considered a war crime. It was just considered a violation of the laws of war and occupation, and compensation for violations of the laws of war were mainly negotiated and done between the culprit state, the state alleged to have violated the laws of war, and the one, or the victim state, and they would negotiate and compensate and those kind of things. It wasn't until 1919, after World War I, that the Allied powers, it was Japan, the United States, France, and Great Britain, that are going to come together under a commission and identify certain categories or headings of war crimes. Because what they're going to do is, after World War I, they're going to start prosecuting Germans and their allies individually, not the state, but individuals for war crimes, both military and civilian. So they identified things such as mass murder, rape, pillage. They were now codifying it under a war crime. In particular, they said confiscation of property is a war crime, as well as usurpation of sovereignty during occupation. Now, the word usurpation means the unlawful exercise of sovereignty during occupation. The reason why that heading came up under war crimes regarding German soldiers or military officers and civilians, because Germany was imposing their laws in occupied territories during World War I. Okay? So like in Belgium, they would be imposing their laws as well as their rules in their courts. Okay?
So Germany was taking over or conquering another country and using German laws in another country.
Well, they weren't conquering it because conquest implies they are part of that country.
Oh, I see.
They were occupying it.
Okay.
So when you occupy a territory during war, that doesn't mean you have sovereignty there. Sovereignty is still intact. What you have is a temporary authority to administer that sovereignty. But the sovereignty you're administering is not your own from your own country, but rather the country you are occupying. So the term usurpation of sovereignty during occupation was the unlawful imposition of German laws and German courts within occupied territories. That could lead to confiscation of property. That could lead to, let's say, executions, jail terms. So these things became a major issue regarding, for the first time ever, the prosecution of individuals for war crimes. Now that process continued, identifying these terms. It was maintained, these headings, even up to World War II. And World War II, they were using those same headings to prosecute Germans and Japanese, namely usurpation of sovereignty during occupation. Now, one argument that was made, and I agree with it, one argument that was made was that they were preparing to prosecute German nationals for usurpation of sovereignty during occupation, namely judges. Okay? They were manning courts that were illegal in foreign countries. So the court itself was a war crime. But the argument made was, well, the judges in these courts should not be considered as to have committed a war crime unless these judges themselves provided an unfair trial.
It's interesting because when people think of a war crime, they think about, the killing of somebody else. For example, they think about genocide, that kind of thing, but they don't think about, judges imposing, laws of their country upon another people in another country.
Right. Because the issue of a fair trial is really important, because if you don't receive a fair trial, that could lead to an execution, that could lead to the confiscation of your property, that could lead to a fine. Yeah. So the unfair trial aspect of committing a war crime was what was being argued after World War II, in that German judges in a foreign state administering German law could not necessarily have committed a war crime if they provided an unfair trial. Now, if they provided an unfair trial, then that's a war crime. Okay. Now, the argument was, but if they provided a fair trial, let's say you're brought up for theft, and you have evidence that said, I didn't do it, and then the judge dismisses the case. He acquits you. That's getting a fair trial, even though it was in an illegal institution. So the judge itself, according to this theory that was presented after World War II, was, then you can't consider that judge to have committed a war crime, although he was sitting in a court that in and of itself was established as a war crime, because that was under the usurpation of sovereignty during occupation. Now,
So explain that in layman's terms. What does that mean?
although the court was illegal, the private judge could not be considered to have committed a war crime himself if he provided a fair trial. But the court itself was illegal. Because when you talk about war crimes, you're talking prosecution of an individual, not the prosecution of a court. That's what they were saying. So the usurpation of sovereignty during occupation and the court itself not being legal, well, that would be an issue that Germany would have to answer as a state, not necessarily the individual judge who was sitting in that court that Germany created in that foreign state.
I see.
Now, when you move into the issue then of the unfair trial, well, that's what prompted the idea or the fact of an unfair trial to be actually categorized as a war crime itself. Now that didn't come about until 1949, the Geneva Convention. Now the Geneva Convention basically dealt with civilians, the protection of civilians during occupations. That was Geneva Convention number 4, the 4th Geneva Convention of 1949. Article 147 in the Geneva Convention specifically says now that for a person to willfully deprive a protected person of a fair and regular trial, that's a war crime. So now they got specific. So that theory that was being used to try to protect judges after World War II, that maybe they didn't commit a war crime because they provided a fair trial, they moved further to codify and add an unfair trial as a war crime itself, in addition to the usurpation of sovereignty during occupation.
War crimes doesn't necessarily only apply to trials. It could be actions also. Is that right?
Right, absolutely.
Can you give examples?
Well, let's give the example of a court issuing an order that doesn't have jurisdiction, like what we have in Hawaii. And that court was challenged, and evidence was clear that the court didn't have jurisdiction, and the judge disregarded it and moved to issue a writ of possession or ejectment. Okay, that judge right there provided an unfair trial. Okay, so that judge, by the evidence, committed a war crime. Now, once that order of eviction or writ of possession is issued, now if law enforcement, sheriffs, police, processors, if they carry out that order, they become an accessory to the war crime, because the carrying out of that order will lead to the dispossession of property where property cannot be confiscated. So you're now looking or realizing here that you have an initial war crime committed for an unfair trial, and now it's moving into another war crime, which is confiscation of property, which cannot be done during occupations.
Okay, so this leads me to the next question. How is it that war crimes are now being committed in Hawaii?
Well, as we covered in the past shows, Hawaii is not a part of the United States. It never was. It's not an argument. Okay, and the only way that Hawaii can be a part of the United States, you have to have a treaty. A treaty whereby Hawaii basically ceded itself to the United States of America. There is no treaty. What we have is what we have our lives, a revisionist history. Now people might say, yeah, but that's Keanu's opinion. No, it's not my opinion. Well, actually it's my opinion, but it's a qualified opinion because I have a PhD in this area. My PhD is in political science. I specialize in international relations and public law. Well, there is no doubt. There is no treaty. That's a fact. Okay. Now, if there is no treaty, then Hawaii is not a part of the United States. And even though people think it is, it's not. So you might say Hawaii was kidnapped in 1898 during the Spanish-American War, but it was treated like it was adopted. The fact that people believe they're adopted does not mean they're adopted. And that belief of adoption is actually directly attributable to the misinformation and revisionist history that is now becoming the topic of major research at the University of Hawaii. So when we see the issue of Hawaii now, Hawaii is not a part of the United States. It was never annexed. The proper term to use, it's occupied. Because if Hawaii is not a part of the United States, it's still its own country, as it was an independent state since 1843, November 28th. Okay, that was the formal proclamation by Great Britain and France, formally recognizing Hawaii as a country, as an independent state. That hasn't changed. Now, because Hawaii is not a part of the United States, the question is, well, how did Hawaii become a part of the United States, or how did we think it became a part of the United States? Well, it goes back to 1898, the Joint Resolution of Annexation. Now, the Joint Resolution of Annexation is a congressional law enacted by Congress purporting to have annexed a foreign country. That joint resolution cannot annex anything because it's limited to U.S. territory. The United States Congress could no more annex Hawaii by passing an internal law, a congressional law, than the United States Congress can pass a joint resolution today annexing Mexico. Enacting a joint resolution today annexing Canada, it can't. Well, that's what they did in Hawaii in 1893, but they disguised that joint resolution as if it was a treaty. That's why today we say ceded lands, as if Hawaii was ceded to the United States. You need a treaty to be ceded. There is no treaty. Hawaii wasn't ceded. Now, when the United States government, its Congress, went further to create a government for the territory of Hawaii, that was in 1900, also known as the Organic Act. That Organic Act, which created a government for the territory of Hawaii, whereby the president would appoint the governor, that act is still a congressional law, limited to U.S. territory. And then in 1959, the U.S. Congress passed another law, transforming the territorial government into the state of Hawaii government. Again, that 1959 Statehood Act is an American law passed by Congress. Now, under U.S. constitutional law, it is clear that congressional laws do not have any force beyond its borders. U.S. Supreme Court decisions, basic constitutional law says that. Okay? So we know from a constitutional standpoint, under U.S. constitutional law, congressional acts, which includes the Statehood Act, has no force beyond the borders of the United States. So if Hawaii doesn't have a treaty with the United States, Hawaii is not a part of the United States, therefore, the Statehood Act cannot be applied here. Now, once you impose the laws of one country, which is limited to U.S. territory, into the territory of another country, namely the Hawaiian Kingdom, now you're getting into a war crime. That's the international law perspective. Now, U.S. law perspective, limited to U.S. territory. International law perspective, well, when you take that law and you impose it in a foreign country, that falls under the heading of usurpation of sovereignty during occupation.
So the key, in order for the United States to have been able to legally impose U.S. law in Hawaii, was to have legally the Treaty of Annexation.
Right? Not legally impose, because impose meaning it's not legal, but to legally apply U.S. law here, you would need a treaty. Just like to legally apply law, U.S. law in Tijuana, you need a treaty that allows those laws to be in Tijuana. Otherwise, Tijuana is under Mexican law.
So to clarify it with all of our viewers, that's watching this show, that to make it clear that there was never a treaty of annexation between the Kingdom of Hawaii and the United States, and it doesn't exist.
There is no treaty between anybody, let alone the Kingdom of Hawaii, the United States, and the Kingdom of Timbuktu. There's no treaty at all.
Okay.
Yes.
So, as the courts today that here in Hawaii, they're imposing U.S. laws over everybody. And by doing that, the consequences of the judges are...
Well, let's kind of back up first.
Okay.
The state of Hawaii, created by an act of Congress, imposed in a foreign country called Hawaii, is a war crime.
Okay.
So the state of Hawaii government, by definition, under international law, is a war crime. It's an extension of a war crime. Under U.S. constitutional law, the state of Hawaii, or the Statehood Act, is limited to U.S. territory. But under international law, it's an extension of a war crime because that is an extension of U.S. sovereignty beyond its borders. No different than what Germany was doing in Belgium during World War I.
Nice.
Okay? And it was the United States that helped establish that war crime, which is called usurpation of sovereignty during occupation.
What about the state of Hawaii legislature when they make laws? Is that a war crime?
Everything stemming from the state of Hawaii government is a war crime.
Okay.
Because it comes from a war crime. Okay? So you cannot, so there's this rule of evidence, okay, that goes, you cannot get a legal fruit from an illegal tree.
Ooh. Oh.
Yeah.
Yeah, that apple.
Yeah.
That we shouldn't have picked. That was poisonous, especially the PLDC apple. Oh, poisonous fruit.
Well, it's
For those of you that are interested in PLDC, that's an illegal law. That's a work. Now I'm. Okay. So let's stay with war crimes.
Yeah. Now, war crimes again are placed upon individuals. The state of Hawaii as a government is an extension of a war crime. That's an extension of the United States. That's the war crime. And the United States will have to answer to that as a country, okay, for compensation, for violations, and so forth. But the war crime itself, regarding individuals within the state government, okay, that's a different matter, okay, because individuals have to commit a war crime. Now, in particular, Article 147 of the Geneva Convention, number 4, says that if a judge deliberately deprives a protected person of a fair and regular trial, that person committed a war crime. So now, we already know the courts and the state of Hawaii government is completely illegal if Hawaii still exists as a country. That's why it's illegal. Now, the individuals within the state of Hawaii government, in particular the judges, if they are presented with clear evidence that this court doesn't have jurisdiction, and they disregard that evidence, and they deliberately prevent a person from having a fair trial, that's a war crime.
Okay, so let's be specific. Let's talk about a case that took place, if you know about.
Well, what I do know of is Judge Hara.
Okay, let's talk about Judge Hara.
Okay, well, Judge Hara, in this particular case, there was a defendant named Elaine Kawasaki, and she's from Hilo. And Elaine Kawasaki was represented by Dexter Kayama, an attorney. In her case, a motion to dismiss was filed, okay, and Dexter provided special appearance to make the arguments. And in that motion to dismiss, clear evidence of Hawaii not being a part of the United States was provided. Clear evidence. And number one, there's no treaty between Hawaii and the United States that made Hawaii part of the United States, but more so, there were 2 executive agreements entered into between the Queen, Lili'uokalani, and President Grover Cleveland. These 2 executive agreements settled the overthrow and called for the President's office through the military to administer Hawaiian law, and then to prepare for restoration of the government and return an executive power that was temporarily assigned, and thereafter the Queen to grant amnesty, a pardon to these insurgents who committed treason. These agreements are binding treaties under international law. Judge Hara was requested by Dexter Kayama, the attorney, and I'm getting this all from the transcripts, to take judicial notice of these executive agreements. Now, when a judge takes judicial notice of evidence, what they'll be saying is, this evidence is irrefutable. Now, according to the Hawaii Rules of Evidence,